public hearing.
Just before we turn the audio on for the video feed, can we do the recording at 1.5 times playback? It's very slow, right? You already got that? Okay, all right, great. Yeah. Okay, we're gonna get going. I think everybody that's gonna be here is here. So with that, I'll call the regular meeting of Township Council for the purposes of a public hearing to order. Of course, I'd like to begin by acknowledging the traditional territories of the Coast Salish peoples, and in particular, our valued relationships with the Katzie, Kwantlen, Matsqui, and Semiahmoo First Nations. That, could you read the preamble, please?
A public hearing is a statutory requirement under Section 464 of the Local Government Act and must be held before third reading of a community plan land use contract amendment bylaw, heritage designation bylaw, or heritage revitalization agreement bylaw. During a public hearing, council acts in a quasi-judicial role for the purpose of allowing persons who believe their interest in property is affected by a bylaw, permit, or other matter to make representations to council, either orally, by written submission, or to add comments to or elaborate upon correspondence that may have already been presented to council concerning the bylaws. It is important to note that council is not able to receive any additional information on the bylaws following the public hearing as dictated by case law. The hearing procedure involves an explanation from the Community Development Division on the purpose of the proposed bylaws and to hear from individuals regarding the bylaws. In order to ensure that all interested parties have a reasonable opportunity to be heard, speakers are requested to keep representations as brief and succinct as possible and no longer than 5 minutes in duration, excluding the time required for questions from council. Speakers will be asked to state their name, neighborhood, and city for the record. And if referring to prepared remarks, to submit copies of these to the township clerk. Decorum must be always maintained. This includes refraining from applause, booing, or heckling. To assist with large numbers of speakers, individuals must advise the township clerk and sign the speakers list prior to the commencement of the public hearing. The names on the speakers list will be read out during the hearing. Individuals who have already addressed council and wish to add further submissions will wait until the people that have not yet addressed council have had an opportunity to speak. All submissions and speaker lists are considered part of the public record. Council members should not express their views nor debate the bylaws. However, they may question speakers to clarify particular points in their submissions. Council may consider third reading or third reading and final adoption at this meeting or at its next regular meeting. Thank you.
Great. Get a motion to adopt the agenda, please. Moved by Councillor Rint, seconded by Councillor Ferguson. Call the question on A1. That carries unanimously. Now, Mr. Cooner, item B1.
Yes, Your Worship. Item B1 is a subject public hearing which relates to an update to the official community plan. Bylaw number 5994 updates housing policies in the official community plan to include minimum requirements for the provision of 3-bedroom units and new apartment development applications with 10 or more residential units. As directed by Council Resolution on December 4th, 2023, bylaw number 5994 requires that a minimum of 10% of total project units be at least 3 bedrooms in buildings that are 6-story or less, unless otherwise stated, that a minimum of 5% of the total project units be at least 3-bedroom in the building that are 7 stories or more, unless otherwise stated, and that the overall average unit size be 750 square feet, which is approximately 70 square meters. Newspaper advertisements for the proposed bylaws did run in the Langley Advance Time on February 14th and 21st of 2024 editions, which met the Local Government Act requirements under the Act. The proposed bylaws were provided to the UDI Langley Liaison Committee for information. UDI members were encouraged to submit their comments at this public hearing. 0 written submissions have been received, and there are 0 individuals noted on the speakers list.
Great. For a first time, is there any submissions from the public on item B1? For a second time? But please come forward.
Good evening, all respected council members and as well as Mayor. For the item number B1,
We just need to get your name, city for the record.
Rish Kumar Mehta, living at 20547 in the Salmon River Uplands and City of Langley Township, sir.
Great, thank you.
And just wanted to bring a couple of points with regards to the bylaw number 5994 B1 item and amendments coming to. I want to highlight the point about the British Columbia's 2023 legislation bill, which is Bill 47. As we are aware that in 2023, the province legalized fourplexes, which allowed the apartment buildings up to 20 stories near the stations, eliminated the public hearings for plan-compliant buildings, and ended parking requirements as well. However, it is important to make sure it is important to note down here that while Cascadian jurisdiction have been struggling to adopt the requirements for reducing the parking, it is equally important that what Bill 47 in the British Columbia is about building at least up to 20 stories, which is next to the SkyStream station, legalizing the fourplexes, and as well as making sure about that the proposing a single stair apartments, which is set up a new standard, a zoning reform. Bill 47 is about a zoning reform that I wanted to highlight here. And also I wanted to make sure that it created a framework for the Canada's best neighborhood in the future. That housing bill has been introduced in the Parliament in the 2023, the British Columbia Parliament. Also to make sure that one of the important legalization apartment in BC is to make sure about the formidable zoning regulations. That is one of the current issues with the city of Langley Township. There are commercial and there are residential zones. Between both the zoning, there is a differentiation of old housing and new housing, whereas the new housing bill only addresses where you want the entire housing community to be developed near more urbanized area, creating more urban space. Whereas the agricultural land and the rest of the complexes or the land utilization remains to be the same. That means making the city more commercialized and the suburban remains to be the more agricultural reserve land. That is the Bill 47 is addressing. Also, one of the important factor for the executives and councils to consider here is that you are dropping some of the key components of addressing the suburban areas. When developing a housing bill, it is important to address that which suburban area is to be developed. If it's already a commercialized, then the zoning reform would be required. But being the within 20 stories fourplex is creating near the SkyTrain station would not be that much of a hassle for the city of Langley Township. Thank you very much for listening to comments.
Are there any other submissions from the public on item B1? For a second time, are there any other submissions from the public on item B1? And then for a third and final time, are there any other submissions from the public on item B1? Seeing none, I'll close the public hearing on item B1. I will move consideration of third and final reading, seconded by Councillor Rent. Call the question on B1. That carries unanimously. I'll move it. Is there a seconder? Seconded by Councillor Rent. So I also have an amendment. There's 4 amendments, and what I'm going to suggest we do is people can consider the amendments. They're fairly substantial. I would suggest that we then refer this for a subsequent public hearing. So we would these would accomplish removing the distinction for building height, 15% for 2 bedrooms, 10% for 3 bedrooms, and then a reduction of the overall average unit size to 700 square feet or 65 square meters, and an extension of the grace period. Is there a second to this amendment? Seconded by Councillor Rent. Any discussion on these amendments? And if people want to take a few seconds to read them, that's fine. Councillor Ferguson.
I just wanted, if I may, to refer it to a public hearing, please.
Yeah, so once they're adopted, we would have an amended third and final on the floor, and then we would refer that to a public hearing.
Okay.
That would be my suggestion after that. Any discussion? Seeing none, I'll call the question on the amendments to B1. That carries unanimously. I'll move referral of that to a public hearing, seconded by Councillor Rent. Any discussion on that referral? Ms. Little, is that wording sufficient?
Yes, that's sufficient, but it won't be the next public hearing. It will be the one after.
So I don't know when the next public hearing is.
Unless we...
Is it the 15th or the 29th?
The next meeting is April 15th. The following meeting is April 29th.
So it'll be the public hearing on the 29th.
Correct.
That's correct. That's fine. So that language is sufficient for that?
Correct.
Okay, great. Is there any discussion on that referral? Seeing none, I'll call the question on the referral of B1. That carries unanimously. Get a motion to terminate. Moved by Councillor Rent, seconded by Councillor Martins. All those in favor, opposed, and carried. Thank you.